1. Constitutional limits on judicial power. Article 3's narrow mandate. The U.S. Constitution, particularly Article 3, establishes the federal judiciary and vests the judicial power of the United States in one Supreme Court and such inferior courts as Congress may create. This provision was meant primarily to provide a forum for resolving disputes and interpreting ambiguous statutory language, not to empower judges to create entirely new rights, or to strip away those the Constitution protects. In its plain reading, Article 3 does not say that judges may impose restrictions on rights. It merely creates a branch that, when disputes arise, must interpret the law. No explicit grant for rights restriction. Critics argue that nowhere in the Constitution is there an express grant giving judges the power to rewrite or modify the rights originally set forth by the document, the framers. It is intended for any fundamental change in rights or the limitations on them to be made through the rigorous, democratic amendment process, not through judicial interpretation. This viewpoint holds that judges are supposed to resolve uncertainties in language, not to act as policymakers who decide which rights survive in a modern society. 2. The legacy of Marbury v. Madison. Establishing judicial review. In Marbury v. Madison 1803, Chief Justice John Marshall famously declared that it is emphatically the province and duty of the judicial department to say what the law is. Constitution.congress.gov. This decision is often cited as the foundation for the power of judicial review. Yet, critics claim that Marshall's ruling did not merely empower courts to resolve conflicts, it effectively granted them the power to determine which laws, and by extension, which interpretations of rights are valid. They contend that this decision, rather than serving as a neutral check on the other branches, has enabled the federal judiciary to step into the role of a de facto legislator, a gateway for expanding restrictions. Opponents assert that the doctrine of judicial review has been used as a tool to allow judges to evolve constitutional rights, the so-called living document approach, in ways that may restrict them over time. Rather than interpreting ambiguous language in a way that preserves the original protections, judges have, in some cases, interpreted the Constitution to justify no limitations on rights. For critics, this amounts to an overreach, a transformation of judges from interpreters of law into creators of law, with the power to effectively diminish the rights the Constitution was meant to guarantee. 3. The living Constitution. Debate interpretation versus legislation. Proponents of a living Constitution argue that broad, sometimes vague language was intentional. They claim that as society evolves, so must the application of constitutional principles. Yet critics counter that this argument simply provides a post hoc rationale for judicial activism. They insist that if the framers wanted rights or limitations to change, they would have provided for a formal, democratic amendment process. Instead, judges unelected and serving for life now have the final say in what our rights are, a shift seen by critics as dangerously undemocratic. Restricting rights or adapting protections, while advocates of the living Constitution assert that evolving interpretations protect citizens by adapting to contemporary challenges. Detractors see it as a pathway to restrict rights. They argue that judicial decisions that narrow long-settled rights are not neutral applications of timeless principles, but rather subjective determinations that open the door for government overreach. From this perspective, Marbury v. Madison is less a safeguard for rights than an enabler for a government apparatus that, through judicial interpretation, can undermine them. 4. Political implications and calls for accountability. A call to political leaders. Critics of the current judicial approach contend that the judiciary has morphed into an unelected, unaccountable branch that, in the eyes of many, is actively curtailing freedoms under the guise of constitutional interpretation. They argue that elected leaders, who are directly answerable to the people, should step in. For instance, voices on the political right have urged figures like former President Trump to take action to protect their rights from unlawful, inconsistent, and dangerous judges. The idea here is that if judges are overstepping their limited, constitutionally prescribed role, then it falls to the political branches representing the will of the people to restore the proper balance. Democratic remedy or judicial overreach? Critics maintain that by bypassing the amendment process, judicial decisions that restrict rights lack democratic legitimacy. They argue that the only proper way to change how rights are understood is via the constitutional amendment process, not through what they see as an expansive reading of ambiguities by lifetime-appointed judges. This line of argument asserts that judicial review, as practiced today, has effectively given the government through its judicial arm the power to dismantle the very rights the Constitution was meant to secure.
In summary, opponents of expansive judicial interpretation argue that Article 3 was meant to resolve ambiguities, not to act as a tool for reshaping rights. Marbury v. Madison established judicial review, but in a way that has since been used to justify restrictions on rights. The living constitution theory is seen as a pretext for judicial activism that strays from the text's original meaning. Fundamental changes to rights should occur through constitutional amendments, a process driven by democratic input, not by unelected judges. Elected leaders, like those championed by former President Trump, should step in to rein in what they view as judicial overreach and to safeguard the rights guaranteed by the original Constitution. While this perspective is passionately held by some, it remains a subject of deep debate in constitutional and political discourse. The tension between a fixed original meaning and a dynamic, evolving interpretation is at the heart of American constitutional law and is likely to remain so as society continues to change.